Good day, everybody. I hope you can hear me okay. My name is Willem Lombard, and welcome to our webinar this afternoon. I think it's our 10th webinar. Many of you have attended in the past, so you know what to expect. And welcome to you, and then also, of course, the newbies. Thank you for joining us on this Monday afternoon and for taking this time. I know it's squeezed between a weekend and a public holiday, so I'm very happy that you're able to join us on this awkward day in the middle of two holidays. I'd also like to take the opportunity to thank Greatsoft for hosting us this afternoon and for inviting your members. So thank you very much to Byron and the team for this opportunity. There will be a recording of this session. The recordings are published on our website, which is www.taxrisk.co.za. But please give it a few days before you try and find it on our website, because it does take a few days to process it. But there are recordings of our previous sessions on the website already. So if you have missed one of the previous sessions, please go to our website. You go to the media page and you'll see a recording of all the previous sessions that we've hosted. And you're more than welcome to have a look at that. This is a CPD webinar. There's 1.5 hours CPD on offer, but please just keep in mind that you have to attend the whole 1.5 hours session to qualify for the CPDs, as we can't give portional CPD points. You have to attend the whole session. So, and then lastly, just if you have any questions, please put it in the chat box. We'll keep an eye on the chat box as we go, and then at the end of the presentations, we'll then cover as many of those questions as we practically can within the 1.5 hours allotted. If there are any leftover questions, we'll then follow up on that afterwards. But then, of course, we'll offer you our contact details, and then you're always welcome to contact us afterwards if you have any questions or suggestions in that. So please, your questions in the chat. Right, that's it for the public service announcements. I think the next part is to introduce our keynote speaker for today. For those of you who've attended before, you already know Dr. Erasmus. But for those of you who haven't met him yet, just a short CV about who Dr. Erasmus is, and I'll read it for you. Dr. Erasmus is an international tax attorney. He is a US enrolled court agent, a US tax court practitioner, and widely recognized for his work in tax risk management, domestic and international tax of multinational organizations, and transfer pricing in South Africa and Africa. He's an adjunct professor at Middlesex University in London and has published and co-authored several tax books, as well as doctoral theses, Information Gathering Power of SARS and Audits and the Constitution. So Dr. Erasmus, thank you for your time again this afternoon. You are welcome to share your presentation now. There we go. Thank you very much, and good luck. Thank you, Dr. Erasmus. Over to you.
Thanks, Willem. Good morning to everybody. I take it, in fact, no, it's good afternoon because you're all in South Africa. I'm speaking to you from the sunny state of Florida, but I do frequent South Africa often with my practice. Many of you have attended my talks and webinars in the past. So I'm asked to just share some of the emerging issues that are important to you as tax practitioners. And today's one is about a very interesting matter, which in fact is not new news. It's just received an extreme amount of publicity because it was reported in the media, and so a lot of tax practitioners are talking about the Supreme Court of Appeal Poulter judgment. Interesting thing is the tax court, as it's been constituted way back from 1962, has never required the persons appearing in the tax court to be qualified lawyers, attorneys, or advocates. Any person has always been able to appear in the tax court, which incidentally is not a tax court in the proper sense. Now that we have a constitution, it is regarded as an administrative tribunal. So it doesn't have the same status as a tax court. It has a high court judge that will be appointed to sit as judge, sits with two assessors, a business assessor and an accounting assessor. And interestingly enough, you can make application for a special type of assessor depending on the special circumstances of your case. Let's say, for instance, a transfer pricing matter or something to do with black economic empower deductions. But be that as it may, the very recent United Kalahari Manganese judgment that I spoke about in previous webinars, a constitutional judgment by Justice Owen Rogers, who's a well-known previous senior counsel in tax work, wrote an excellent judgment and really gave a thorough analysis of what the tax court is, where it fits in the Tax Administration Act, what its function is, and its function is the trier of fact. It's the place where it's been designed for any assessment that is the subject of an objection can basically, the words are de novo from afresh. The tax court has the jurisdiction and the power to look at all the information that SARS had looked at previously and anything additional, and override effectively the decision that SARS made previously, depending on the outcome. So that's always been a forum where anybody can appear. There are a limited number of accountants that appeared over the years, but it was never common knowledge. And so what all that Poulter did was to bring it to the forefront to say, listen, now that we've analyzed it, and the interesting facts were Gary van der Merwe appeared as the counsel for his daughter, and I'm not going to bore you with all interesting reading, but a huge matter, a huge donation was made to her, and it was called into question, whether this was taxable or not. He appeared. SARS obviously got irritated with the fact that he kept on making appearances, and of course, a fairly litigious sort of fellow under these particular circumstances. And SARS then decided to challenge his authority to act on her behalf. And ultimately, it went all the way to the Supreme Court that, came out with a judgment to say anybody can appear. Of course, you can't appear once the matter goes on appeal to the High Court, or if you were to bring a High Court application, or if the matter goes to the Supreme Court or the Constitutional Court, except, interestingly enough, if it's your own case, then of course you are entitled to appear. And the courts will allow directors of a company to appear. So that's an interesting sort of exception to the rule that you have to be represented by a qualified, experienced lawyer. When I say qualified, experienced lawyer, I mean a lawyer that's passed a bar exam. That does not necessarily mean that they are competent enough to appear on your behalf. And that really says a lot about this judgment, which now has brought to the fore. SITE ran a survey, and a large percentage of people said that they would very much like to appear in the tax court for and on behalf of their taxpayer clients. And 25% of those people said, we're ready to appear, which kind of shocked me. And so I had discussions with the CEO of SITE, and who interestingly enough is a former professor from the United States, and he was reminded by me of the process here in the United States, which is an interesting one. The United States has a similar process where tax courts are created by means of legislation, but the judges are specifically appointed by the president, and they are usually judges that are always dedicated to the tax court. I think there are roughly 25 that sit at any given point in time. It's a traveling court, so it doesn't have a permanent location. It will travel to different locations, different cities. But those judges always are experienced former IRS officials or in some instances from private practice who have a tax background, so they are experienced in tax matters. It's a very prolific court system. You can look up the US tax court judgments online. The judgments are reported. Most of the judgments are reported, and it is quite prolific, as most things are in the United States. The unfortunate thing is, of course, the federal tax laws are quite different to what we have in South Africa, but certainly there are principles that align with what we do. And you'll see one of the areas that I like to go and look at the American side of things is the law of evidence, because the Americans like to codify common law, meaning that they like to take the common law and write it up in the form of a statute, but really just a transcript honing in on common law principles. And the federal rules of evidence are a great body of law which really has documented the common law pertaining to the law of evidence. And so that becomes a very interesting vehicle or place to look at specific areas of evidence insofar as they impact tax disputes, but that'll become more evident as I go through my presentation. And coming back to the discussions I had in the United States, interestingly enough, you have to pass a fairly heinous exam. And so on the screen in front of you, you've got sort of a table summarizing what that looks like. And the exam is made up of 4 sections. 25% is tax court rules and procedure. 25% is the federal rules of evidence that I was just mentioning. 10% is professional responsibility. And then 40% is federal taxation. So 40% would be the area that most tax practitioners are proficient in, but only 40% of the paper makes up the entire exam that comes around every 2 years in Washington, D.C. 60% of it pertains to procedural issues, showing how important procedural issues are if you're contemplating on representing a taxpayer in a tax court. And interestingly enough, you have to get 70% minimum in each and every one of these sections, with an overall minimum 70% to pass the exam, and which makes it very difficult. I was at a conference once with some of the judges of the tax court, and they jokingly said they don't know if they would be able to pass the examination. It's so difficult. And to illustrate that, since the 1940s, when this exam was first created, and as I said, you sit every 2 years, it's available. It's not available all the time. Less than 300 practitioners have passed the exam. I mean, that's quite a remarkable number. And it also shows that it's ridiculously too difficult. So when the year that I sat, which was 2010, there were 96 people that sat and wrote the exam in Washington. Only 6 of us passed, of which I was fortunate to be one of those. Now, I'm not suggesting that South Africa introduces something as difficult as this, because I think it really is a way of trying to block non-lawyers from participating in the tax court system. The interesting thing is, if you're just a normal attorney, you pay your $50, I think is the latest fee, and you get a tax court certificate, and Bob's your auntie, you can appear, which is ridiculous, because you all know, as tax practitioners, the technical aspects of tax are really quite difficult, and so it's not something that most lawyers have been trained in. And so what I wanted to do is just for a minute or two, just show you. In fact, let me go. This is one of the exam papers. So they, because it's such a difficult exam, they post all the past exam papers. But here are the evidence questions. So this becomes a really important part of training to be competent to appear. So as much as all of you can appear, question is, are you competent to appear? Bearing in mind that oftentimes your opponent acting for SARS is going to be a senior counsel with a junior counsel. So the case that I'm arguing at the moment on Black economic empowerment deductions, which we didn't finish in Durban in February, my opponent is a senior counsel, been at the bar for probably close on 30 years, assisted by a junior counsel, and I'm standing, so which I'm quite happy to do. I'm solo up against them. I certainly have the experience and expertise. But if you're somebody that is new to the game and you don't really understand and know and have experience of what you're doing, it's going to be very difficult for you to stand up against that sort of level of competency. And my opponent in this particular matter is one of these very authoritarian type of advocates that come out of certain bars. When I say bar, I mean advocate bars in South Africa. A very nice guy outside of court, in court, real tough sort of authoritarian person. And you know, I can imagine could be quite intimidating. It certainly is intimidating towards witnesses. And if you're not really skilled in this and know how it's going to pan out, it's going to be a difficult feat for you in court. Anyway, look at the. I'll send this out, but here here the first question is they give a set of facts and they say the case in chief, the TP stands for taxpayer, seeks to admit a document into evidence. The document contains an IRS certification cover sheet and the document bears an IRS seal. The following words appear at the top of the document, the 140 Instructions 2013. The bottom of the document appear. So this is an official document. The TP represents to the court that he would like to admit Exhibit 1 into evidence for the truth of its contents. If the IRS does not challenge the authenticity of the document, but instead urges its inclusion on hearsay grounds, how should the court rule and why? So there immediately it introduces interesting questions. Firstly, do you have to prove the authenticity of that particular document? And more so, if that is being submitted to prove the truthfulness of its contents, because that document was prepared by a third party, not the party that is introducing it as evidence to court, it is theoretically hearsay. And so could the IRS, or in this case SARS, object to its admission as being a hearsay document? So that's just touching it. I mean, that's just touching the tip of the iceberg. Evidence is an extremely difficult subject. It's one thing reading reams of evidence books. It's another thing taking those principles and applying them in practice. And I remember preparing for this exam, we went through reams and reams of different scenarios on how one would tackle and deal with questions of evidence. So it's just one of the areas where you would need to really skill yourselves up. And so towards that goal, my job is to point out to you in this webinar the things that you really need to be looking into to get to the place where you're able to appear in a tax court down the line. And to that end, I've asked Gil Ferreira, who runs the courses that I lecture on as adjunct professor. He runs two shorter courses. One is on tax disputes in South Africa, which is a course that is coming up in the next week or so, I think. And then he has designed, with my guidance, a particular South Africa tax practitioner course to educate you as practitioners on the different materials with practical guidelines and with practical sessions to prepare you to be able to appear in the tax court. And I'm going to ask him just to do a very short presentation at the end of my talk, just to explain to you in a couple of minutes what that entails. Because if you're looking at wanting to go down this route, There isn't anything available in South Africa at this point that I'm aware of that is going to assist you in that regard. And so please pay attention to what he has to offer in terms of that in terms of the education. I will be the main educator in the practical course, the second course that he will be dealing with. And we'll be going into great detail into some of the issues that I'm going to raise. Of course, coming to the next slide, what does Poulter not do? Well, it does not permit you as a layperson in the High Court. It does not teach you litigation skills, and it does not remove the need for competency in those forums, as I've already mentioned. Now, next slide, just sort of a key message here, and that is that what modern tax litigation demands from us in order to be competent in a tax court is to understand and know tax procedure. So some of you have listened to my lectures in the past. One of the big things that I've been lecturing on recently is the importance of Section 42 and the letter of findings and the lack thereof. And what are you entitled to do should SARS fail to issue a letter of findings? I'm flabbergasted at the fact that many tax practitioners are unaware of this particular requirement. And part of the confusion revolves around the fact that people say, well, if it's a verification audit, well, it's not a true SARS audit. So therefore, the word audit doesn't come into play. And when you read Section 42, it talks about the conclusion of an audit. And if it's a verification, it's not an audit. So therefore, SARS doesn't really have to issue a letter of findings. And so that seems to be creating some of the confusion. And I want to just address that. And again, this comes to the point of knowing and understanding procedure. The words verification and audit are not defined in the Tax Administration Act, and long-standing Supreme Court case law, the Endumeni case, says that what we should now be doing in interpreting legislation is not just looking at sort of a technical meaning of the word where it stands. We must read that word in its proper context of how it's being used and find and apply it purposively and not restrictively. In other words, when we're talking about verification and we're talking about audit, there has been one fairly recent case where the court looked at what the two words meant, and no doubt those words were put forward by counsel arguing for SARS, and were quite sort of restrictive, saying a verification is really just where you're handing records over for SARS to check. SARS is not obtaining information from third parties to double check that. They're simply just checking the information that you have to support your tax return, and that's what a verification is. Great. However, the moment SARS decides to change materially your tax return assessment by virtue of that verification process, it has now turned into something what I say is akin to an audit. They are now applying their mind. There's reasoning that's being introduced to change the outcome of the assessment, and that aligns with an absolutely fundamental principle of our constitutional law, the audi alteram partem rule. Each party must be heard, particularly if an adverse step is to be taken against them by an administrator such as SARS. That's exactly what happens when a verification audit converts into a quick revised assessment, and an assessment is issued, and then SARS turns around and says, well, we don't have to issue a letter of findings because it's a verification. Well, what they've forgotten and what everybody else forgets is that when there is this material amendment that takes place, effectively that triggers 42. And if I were wrong, then I can assure you that in terms of the Promotion of Administrative Justice Act read with the Constitution, there would most definitely be a requirement for them to give you an opportunity to be heard first. So what that means, and this is where procedure becomes important, if there's this sort of quandary about whether this is a verification or an audit, because of the Kalahari case that I mentioned earlier, distinguishing between what you can do in a tax court and what you have to do in a high court. And if you want to go to the high court, you have to show good cause. You have to effectively ask the high court's permission to come to the high court because you're not using the age-old tax court provisions. And there it would be because the tax court is not in a position to make decisions on the Promotion of Administrative Justice Act. The High Court is. So the High Court, if you explain that to the High Court in your application papers, will say, yes, we are capable and are willing to hear your application. And there you would then say, SARS is raising this point that it's a verification and not an audit. And in that way, it's trying to escape the provisions of Section 42, when in fact the provisions of PAJA are clearly applicable. Please have the assessment set aside. So that's what I mean by procedure. You need to understand those aspects of what you are dealing with. We're not just dealing with tax technical issues that pop out of the VAT Act or the Income Tax Act. Evidence, I've already, and I'm going to come back to evidence, just demonstrated to you a simple question on authenticity. If you don't authenticate the document, it won't be admissible. It doesn't matter how relevant it is. It doesn't matter what the probative value is. And of course, do you know what probative value means? You know, these are technical terms that are pregnant with meaning, and you need to understand and get your head around this stuff. Then there's the question of privilege. You know, you can't just throw any documents into a dossier or into discovery. You've got to ensure that certain privileged documents don't find themselves into the discovered documents folder. And then constitutional rights, which I've already touched upon, and litigation strategy. Do I go high court? Do I go tax court? Of course, if I'm going to go high court, I as a tax practitioner will not be able to appear. I'll have to work with a lawyer that has right of appearance. But, you know, depending on the journey that you want to take your taxpayer down. Right. So now, how do tax disputes begin? Again, repeating much of what I've said in the past. Information requests, which lead to most likely verification audits, interviews, findings, assessments. I've already dealt now with Section 42 and the importance of that. Now, when it comes to information requests, very recent example that I have is where you have multinational operating out of, so I'm going to slow down the pace a little because I want you to visualize this. A multinational, let's say a supplier of a finished product out of the UAE. But that supplier of the product has got subsidiaries scattered around Africa. And the subsidiaries in Africa are involved as contract manufacturers. So they, as contract manufacturers, and let's pick on a few countries, Tanzania, Zambia, Zimbabwe, South Africa, those contract manufacturers wholly owned by the UAE entity that supplies the manufactured product has that product manufactured in each and every one of those countries under a contract manufacturing arrangement. So without going into too much detail, typically a contract manufacturer would supply the product to the UAE at a much lower market value than the open market value than it would supply to a third unconnected party. Why? Because typically the UAE parent company would carry all the risks and responsibilities, financial risks, and any other type of risk of that contract manufacturer. So really the contract manufacturer becomes an extension of the UAE business in each and every one of those countries. So it then is entitled, from a transfer pricing guidelines perspective, it is entitled to send that product to the UAE at a much lower price than what would typically be the case. What happens? Let's say ZIMRA, which is the Zimbabwe Revenue Authority, looks at the entity in Zimbabwe and sees these discounted contract rates going to the UAE, and it also picks up that there are sales of the same product to a third party in South Africa, which is totally unrelated. In other words, in a totally unassociated, unrelated party at a much higher cost. Now it gets hold of the South African Revenue Services, and it asks the South African Revenue Services to get as much information from that entity in South Africa, and particularly what price they paid for a particular product that was purchased from Zimbabwe. It's by way of an information request. Now, those information requests are specifically guided and covered by the provisions of the double tax agreement, in this case between South Africa and Zimbabwe. And the question now arises, are they entitled to ask the South African entity for information in respect of what might have happened in the sale of the product between the United Arab Emirates, the UAE, and South Africa? And so one needs to look at those rules in order to determine whether SARS is allowed to ask you the questions to put that information through and send it through to Zimbabwe. Now, we know that if you simply just give the information, the Zimbabwean revenue authorities will simply look at that arm's length price with a third party that's unconnected and will now transfer pricing adjust telephone numbers for the Zimbabwe entity by saying, you sold for 10, but we see that the UAE sold the exact same product for 20 to an unconnected party in South Africa, and therefore we're going to mark up what you're selling the UAE from 10 to 20. Well, that's not fair and that's not correct because of the contract, the factors underlying a contract manufacturer where all the risk resides with the UAE, whereas with a third party, that's not the case. It doesn't become a comparable arrangement. And if you're simply just handing the information out, what you're doing is without questioning it, you are triggering those types of adjustments that might take place. All of that starts playing a fundamental role in any type of dispute that might now emerge in respect of that particular matter. And you would need to know how to deal with that. So that just gives you sort of insight into how early these disputes begin and how important it is to understand and know what rules are at play. Now, when it comes to audit stage risks, you're now supplying documentation to SARS, and it will be verification records, it might be invoices, it might be contracts, it might be all kinds of information which SARS now looks at in order to arrive at its particular conclusion. Now, remember that question that was put in the exam paper. There was a statutory form that had been completed for the IRS, and the IRS were now questioning the authenticity of that document because it was being handed in to prove the contents of what is in that particular document. Now, that often happens where you're exchanging documents between yourself and the South African Revenue Services. Let's fast track and let's imagine now we're in tax court. So these are the things that you need to know. Typically, before you go to tax court, what the judges sometimes do is they impose the High Court practice note procedures on the litigants. In other words, there's a number of items that you need to work through because the court's just trying to manage the process and narrow down how many issues are going to be argued before the court. And one of the important questions then is on the evidence and the discovered documents. Is it agreed that the discovered documents are admitted into evidence? That is such an important point of agreement because one of the exceptions to the hearsay rule is that if the parties agree, then the hearsay exception or the hearsay rule cannot be applied against those documents that might be hearsay. such as the very document we were going to have to authenticate in my example from that exam paper. By the same token, you often put in that practice note that if any party is going to dispute the authenticity of a document, that they need to give advance notice at least 3 weeks before the trial. And that is so that the party who now has to have the document authenticated can call the appropriate witness or do whatever is necessary to get that document properly authenticated. So we don't get to court and the matter now gets postponed because SARS is now disputing the authenticity of that particular document. So those are sort of, if I say tricks, those are practice issues that you need to know and understand and agree to well in advance of the matter appearing in court. But over and above all of that, there's another very fundamental point here, and that is if SARS has already been interrogating those documents and has never questioned their authenticity and has worked off those documents in order to arrive at their conclusions, for them now to turn around just before you go to court or in court and say, well, we are questioning the authenticity of these documents because you maybe forgot to put that one-liner into the practice note, then there's and in the Civil Evidence Act in South Africa, there is a discretion given to the court if it's in the interest of justice. And this would clearly be one of those instances. It would be an argument to my lord or my lady. It's absolutely ridiculous. SARS has worked off these documents, has never questioned their authenticity, has never questioned their relevance or admissibility for the purposes of conducting their audit and arriving at their conclusions. And they simply now trying to throw up a skittle in order to prevent the taxpayer from discharging its onus of proof. So again, that just gives you sort of an idea of why knowledge of evidence is so important. Now, procedural traps. Again, in going to court and being the party who's going to argue, you're going to have to really understand the tax court rules very well. And there are, my count was 68 rules that, so not all of them are applicable all the time, but there are 68 rules. There are at least 20 rules that are of paramount importance that you need to understand, and particularly when it comes to certain procedures in the tax court. You'll need to know and understand what Rule 31 means, Rule 32, Rule 33. 31 is where once you've filed your notice of appeal, SARS then draws up the first official pleading wherein they set out their grounds of assessment. The grounds of assessment by SARS is set out in the Rule 31. Now, does that Rule 31, does it reflect what was set out in its letter of assessment and its letter of findings? So what you sometimes find is that they said one thing in the letter of findings, then there was a letter of assessment. Okay, and there might have been a difference there because of representations that you made in your response to the letter of findings. And then you object, and then there might be a partial objection allowance, and then the final grounds that remain are the ones that should find their way into the Rule 31. Now, what happens often is the Rule 31 is now not being drafted by the assessor team that raised the assessments in the first place. It's being drafted by an advocate, that senior advocate and junior advocate I was telling you about. And they now put on their clever hats and they start looking at opportunities that the assessor didn't see previously, and they start writing up the grounds of assessment and putting into the grounds of assessment a few extra items that make SARS's case a lot stronger. Are they allowed to do that? So Rule 31 sub 3 plays an important role here, and it says if there is any novation of the facts or law, they are not, then that is not allowed, which gives rise to what should have been a revised assessment. SARS cannot go and amend its grounds of assessment that took place prior to the advocates getting involved to draft the Rule 31. Very nuanced in many cases. Now, there have been two important cases recently reported. The first one was Taxpayer SC. The second one was the BASF case, both matters dealing with transfer pricing. And the precursor to that is the case that I was involved arguing, and that is the ABD, the very famous ABD transfer pricing judgment. And this was the first place where SARS 3 times in a row changed their transfer pricing reports. We decided not to tackle them on the novation point by means of what we call an interlocutory application. In other words, before the matter goes to court, we challenge SARS on switching out these reports. In fact, they switched out their report a month before the trial was supposed to start, so we had to agree to a postponement, which SARS got on the basis that they would pay the wasted costs for preparing to go to trial. What happened is the matter was then delayed for another 18 months before it ended up going to trial. But in the Taxpayer SC case and in the BASF case, the taxpayers decided not to wait to go to tax court and decided to challenge SARS in terms of Rule 31 sub 3 that I'm just speaking about. And in Taxpayer SC, they lost. That was an application brought in the tax court, whereas the one in BASF went further. It went to a full bench, and they won against SARS. Now, what I anticipate is going to happen, because we have a tax court judgment which is persuasive, it doesn't create a set principle like a high court judgment was, and we've got the high court judgment. I have no doubt that SARS will, and I know that the taxpayer has appealed the tax court judgment to the Supreme Court. I have no doubt that SARS is going to appeal the full bench decision to the Supreme Court, and I wouldn't be surprised if the two matters appear in the same appeal matter before the SCA, and ultimately will go to the Constitution Court to see whether these transfer pricing replacement reports gave rise to a novation of the facts and law that SARS had decided upon earlier on in the audit. Interestingly enough, these transfer pricing reports were authored by the exact same expert. In my case, the ABD case, it was an expert out of Europe, and the very same gentleman's name pops up in Taxpayer SC, and again pops up in the BASF case. So SARS got this propeller head in and decided to start changing a bunch of its transfer pricing reports to refine why it was making the adjustments. But the basis for those adjustments were changing quite fundamentally from where it had taken the original decision, its ground of assessment back in the day. So you need to know this stuff. When it comes to the Rule 32, that's the response that the taxpayer puts in. That really now takes the appeal that you've drawn up prior to the Rule 31, and you now set that out in your Rule 32, and you respond to your Rule 31 from SARS. There is a little bit of wiggle room as long as you have covered a particular objection point in the objection and in the notice of appeal. It might not have been very widely described, but you said that a particular item was deductible in terms of Section 11A in the production of income for the purposes of trade, not of a capital nature. You might not have said not of a capital nature, but because you're dealing with you referenced Section 23A Section 11A read with Section 23G. It is expected that the capital versus revenue element may very well have been covered. You just didn't write enough about it in the objection. Again, it creates uncertainty, and you don't want to be in that place. So you want to make sure your objection was properly drafted. So you know, because you're going to face objections from SARS. They're going to say the same thing. Can't amend you can't bring in broader grounds of objection in your Rule 32. So you've really got to know your stuff, and you've got to know, how to draft these objections properly, the notices of appeals properly, and make sure, that your notice of objection is a thorough one. It's as broad as possible so that you're not restricted in what you say in your Rule 32. And then Rule 33 is what SARS is entitled to respond to. So when they get the Rule 32, they might want to pick up on certain of the items. In the complex tax matters I get involved in, they always file a Rule 33 and respond then to what you've raised in Rule 32. Now, prescription mistakes, again, that's a procedural element. One of the matters, in fact, if you listened to my Black Economic Empowerment Deductions webinar, I would have raised that one of the areas that is common with SARS at the moment is they will introduce, well, they'll say that there's been a misrepresentation and therefore they'll ignore the 3-year prescription periods. And there's a lot of very technical law around that, but it's also important that you are able to express through your facts that you're putting forward at the tax court. You're going to win or lose your matters on the facts, not on clever arguments. It's the facts that you put forward which you're able to convince the judge on a balance of probabilities, which we'll come to in a minute. Then you should win the day. Good facts do not save a bad procedure. Again, that's really, I see that my time's running out a bit, but these are elements I will cover in the sort of longer course that I do. But here, for instance, Rule 56 in the tax court rules deals with default judgments. And SARS might have defaulted in procedure, or you might have defaulted in procedure. A judgment can be taken against the party who has defaulted in meeting timelines and not correcting them without even dealing with the merits of the matter. The same goes with the Section 42 that I mentioned earlier. You can simply have a matter thrown out without even going into the merits if SARS has not followed proper procedures. Doesn't matter how good the merits are. And these are things that you need to know. So here I've made the point, matters are won on facts, not on clever arguments. Clever arguments are always great to have, but if you are unable to produce a convincing set of facts, well, you've lost. You can forget it. And that's dependent on a number of elements. Firstly is relevance. Does the evidence that you're putting forward prove or disprove a fact and issue? Okay. The next item you've got to tick off is that even if the evidence is relevant, is it admissible? In other words, does the hearsay rule apply? Is this hearsay that you're putting forward? Is it a privileged communication? Is it an improper expert opinion? Is it an unauthenticated document? Going back to my earlier discussion right in the beginning. Then the next one becomes, is the evidence reliable or credible? So there, it's got a lot to do with the witness themselves. Does the witness come across as an honest person? Is the evidence being given by the witness consistent? What is their demeanor? Do they act in a nervous manner? Does it raise suspicion in the eyes of the court? Or does the witness have a reliable recollection? Have you paired that with documentary evidence so that the witness is corroborating business records? And is the witness's testimony consistent with contemporaneous business records? And business records become fundamental to proving a particular position of a taxpayer in most cases. And then what is the probative value of that evidence? Now that means how much weight should that evidence carry? Now, the taxpayer might say, I incurred this expenditure in order to obtain contracts for BEE purposes. It might be admissible and it might be credible, but a contemporaneous tender document requiring a level 1 triple BEE certificate is usually far more probative, showing that those points were actually allocated in respect of that expenditure that was incurred. It doesn't mean to say you have to push it that far, but I'm just saying that gives you an idea of what would be more probative than simply just referring to a string of emails and oral evidence by the witness. But bearing all of that in mind, remember, on a balance of probability means this. Watch my arm carefully. That. So you must be that much more convincing on your version than SARS's. That's what it means. Of course, when you're undergoing an audit, that's not how SARS looks at the evidence. I mean, they want everything overly convincing. I mean, they want the best evidence. They want you to convince them until par falls off the back of the bus. Of course, you would do so because the more evidence you stack up, the easier it's going to be to prove your case, to discharge that onus of proof. But you need to understand that. And then you need to understand what elements of evidence need to be met in order to get the deduction or to prove that it does not fall within gross income, or whatever the technical provision is that you are working with. Which brings me, to the burden of proof. And as I said to you, the burden of proof is whose version is more probable. It's not who has the better argument. And so one must ask, what is the meaning of balance of probabilities? So other than me demonstrating this to you, which I like to do in court with the judge, this is, you don't discharge that burden through confidence. You don't discharge it through your opinion of what the law says. You discharge it through the evidence. What facts must I prove? What documents prove those facts? Who can explain those documents? How will SARS attack those facts and those documents? That is how you approach what needs to be done. When it comes to the witnesses, they need to be prepared. You can't tell them what they must say, and we'll come to that in a minute when we deal with ethics. But you need to prepare your witnesses because different people are going to react differently. A lot of people are very nervous, and especially when it comes to cross-examination. Cross-examination is designed to test the credibility of what the witness has said. And so if the witness now contradicts everything that they said previously when you asked them to give evidence in chief, the court's going to attach zero weight to what they had to say. So there, the balance of probabilities will go against you. And now you've got to rely on the documents themselves. And that might now also call into question whether those documents are reliable. So you've got to make sure that you have the right witnesses and that they've been properly prepared. I always have moot sessions where I then give the witness an opportunity to experience what cross-examination feels like so that they have an idea of what it is that they're going to be facing. Right, then the evidence toolkit. Well, in our case with tax, you're definitely going to be looking at business records. This is often the most persuasive evidence because you're wanting business records that were created contemporaneously before the litigation was even contemplated. Many of those records are going to be electronic. Now, when it comes to electronic, there's a whole myriad of hoops that you've got to jump through. And the last thing you want to have is to face a challenge of the authenticity of the electronic information. So you might be taking screenshots of what was submitted to SARS by way of e-filing. Well, strictly speaking, if you can't verify the authenticity of that electronic document with the metaphysical process, which is a hell of a process of trying to prove all of that, if you can't reach an agreement or at least in terms of the correspondence when you're exchanging with SARS, saying, here is a copy of the e-filing report where I submitted the tax return together with the annual financial statements that formed part and parcel of the tax return, it then becomes very difficult for SARS down the line now to simply turn around and say, sorry, we don't accept this screenshot because you haven't proven the authenticity of the electronic document. You want to get away from that nonsense. And as I mentioned to you, the best place to do that is out of the Law of Evidence Amendment Act, particularly Section 3, which deals with the exceptions to the hearsay evidence rule, and also deals with these issues of authenticity by the parties agreeing to the submission of such a document. All right, ethics and professional responsibility. Many of you are members of CITE, some of you CICA, some of you CIPA. I mean, there's a myriad of different professional bodies, all of whom have their own set of rules. One of the things that you really need to be on top of is any of the offences in the Tax Administration Act, which deal with, obstructing SARS, submitting false documents, clients saying to you, please don't share this with SARS, when in fact it's a key document and it's going to have to be discovered when it comes to trial anyway. These are questions of ethics that you are going to face, and you need to address them properly. You can't hide information from SARS or from the court. That's considered highly unethical behavior. At the end of the day, you are there to present to the court all the evidence, good and bad, albeit that you are there to advance the position of the taxpayer as opposed to the position of SARS. So there's a myriad of ethical issues that you need to be on top of and ensure that you are compliant with those. What's going to be a good idea is to look at the conduct, the professional conduct that is expected from attorneys, because you're dealing with a situation in a quasi courtroom. And so that's what a judge ultimately is the standard the judge is going to look towards you holding. So ethics and professional responsibility is very important, and it is one of the things that that we would most definitely cover in this particular course. As I mentioned to you earlier, it is a part of the USA tax practitioner's exam, and no doubt will be an important component for you as a person wanting to appear in the tax court. All right, so knowledge and areas to master: Tax Administration Act, objections and appeals, ADRs, tax court procedure, evidence, ethics. These are the areas that you need to get a handle on. And then on top of that, advocacy skills. The advocate's task is to present the strongest lawful argument on behalf of the client whilst maintaining absolute candor and integrity towards the court. The advocate must therefore demonstrate not only why a client should exceed, but why the law requires that result, and without pulling the wool over the court's eyes. So if there are any adverse cases against you, you need to deal with them, and you would be silly not to, because your opponent will, and you're going to look bad by not doing that. So it's nuanced things like that are important. You need to get around. And so the courses that Gilbert will tell you about in a minute or so will cover all of these aspects. In addition to that, remember, now that you are in a position to go this far with representation for your client, this is where, Willem Lombard and the taxrisk.co.za policy plays a pivotal role, because it will fund you acting on behalf of your client. So when you now take all of these necessary steps to represent your client from the moment of the audit, the tax policy is going to kick into play, and it's going to be paying your fees. Right, ladies and gents, I think that brings me to the end of my talk. Any questions? I think if we could have questions put into the chat box. I'm not sure if I should stop sharing my screen and then Willem, you can put your screen back on, or should we just leave it like this?
Yeah, thank you, Daniel. There's no questions yet in the chat box. Would you like Gilbert to do his presentation?
Yeah, Gilbert,
right
if you just give, I don't know if you want to show the audience some of the materials that you have. So let me stop sharing, and or I can share. Gil, over to you.
Thank you, Daniel. Thanks, everybody. Yes, let me just share my website with you, or the website for the Mastering Tax Dispute Resolution course. Okay, there we go. Okay, yeah, thank you for this opportunity, gents. Welcome. And on screen, I hope you can all see that, is the landing page for the Mastering Tax Dispute Resolution program that Daniel spoke about at the beginning of the talk. And Daniel, yes, it starts, well, the first lecture is tomorrow, but it's an induction session. So anyone who's interested in this program, you still have a couple of days to join. I'm not going to go through all the detail. You're more than welcome to go on the site. It's got a lot of detail there, and you can obviously reach out to me as well, and I'll take you through that. But it is really a one-of-a-kind program in South Africa. There are no programs that go into this level and depth when it comes to dispute resolution. The program has been in various guises over the last 20 years. Really started off by Daniel being a real stalwart in tax dispute resolution, particularly in South Africa. And it's gone through various iterations, obviously with updates of the various laws. And currently now it's the lead lecturer is Skalk. I've gone blank now. Skalk Pieterse. Yeah, sorry. I was thinking about the rugby player. Anyway, Skalk Pieterse, and Daniel will also be popping his face in and head in every now and again. But really, it's a program that deals with tax dispute resolution from a practical point of view, from a practitioner point of view, from guys who've been doing this in and out, day in and out, know all the tricks, know all the nuances of what to do and when to do it, and the sharing of knowledge and templates and information you will not find anywhere else. So if you are wanting to skill up on tax dispute resolution, which is probably something that's important in your field, then this is definitely a program to consider. We will be hosting one again later on in the year, but that's all dependent on lecture time and the availability of the lecturers. But currently we are scheduling one for September again. My suggestion is, if this is something that's of interest to you, then look at it, jump on it as soon as you can. But we cover the program overview. We've got the course agenda there. Goes into details, unit 1 to 6, covering all the aspects of dispute resolution. It goes into some detail there. So that's the first course. And then the second course that Daniel was discussing, we're still in development phase, but we will be launching that on the 15th of July, and that is the tax court appearance program. That is a program that will be delivered over 16 weeks. It's a self study, so you do it in your own time. There's no specific join date or time. You will be able to join at any stage, and you will go through the recorded materials and readings that need to be done for that. We will be hosting live lectures once a month, where you can come in and Daniel will predominantly be doing those. So we do have some other people on the panel as well, but you are able to then discuss and raise questions about what you're learning in that forum. And then, as Daniel also said, there will be an exam to test you on your competency, obviously, to make sure that you are ready to be able to appear in tax court, dealing with all the facts, or all the issues that need to be covered. We will be doing 3 exams per year, and so you'll be able to elect when you can do that exam. Once you start the course, you'll have a year to complete it from start to finish, but it should theoretically take you 16 weeks to do. If you commit to it and set your time to it, you can do it within, well, you can do it quicker than that if you can get through the material, but it's really designed as a 16-week program, and then we will issue you with a proper certificate. At the end of it, it is accredited through SITE, so you will get CPD points, and the CPD points are obviously valid across all the other bodies in South Africa. So that's my story. We will be sending out emails within the next 2 weeks talking about the launch of this program and more detail. But I just wanted to raise it in this forum today. And yeah, thank you, Daniel and Willem, for the opportunity.
Thank you, Gilbert.
Over to you, Willem.
Yes, thank you. I'd just like to take a few minutes to tell you about what we do as tax risk underwriting managers. Now, clearly, I mean, from this presentation, the previous presentations, dealing with a complex tax dispute can be complex, even for the most skilled tax practitioner out there. Some of the legal provisions are important and complex to deal with. And at the end of the day, our clients, the taxpayers, are at a loss because most of our clients do not have the wherewithal, the money or the skill to fight a decent battle with SARS, especially if it turns legal. But even if it doesn't turn legal, if it just has to go through the procedures, it is a very complex environment. So what we asked to do is to even these scales of justice between SARS that has all the resources at their disposal and the average taxpayer that has none of that. And we do that through insurance product called tax risk insurance. We're the underwriting managers. We're the people that offer this product. It's underwritten by an insurance company called Bright. And really what we ask taxpayers to do is to put a small amount of premium into an insurance pot. And because it's a risk, you know, being a taxpayer in South Africa is a risk. And if this happens to you or your client, if your client is involved in a dispute with the South African Revenue Service, there's then resources available to pay you as the tax practitioner's fees, and then also to bring in outside expertise like the team that Dr. Daniel Erasmus represents and other tax advisors and specialists to make sure that your client has a fair shake against the South African Revenue Service without breaking the bank. So the next slide just gives you a short definition of what tax risk insurance is, and I'll read it for you because it's just easier that way. It's effective insurance against SARS, tax audits, and related disputes. If an individual, a business, or a trust is selected for audit by SARS, then tax risk insurance will appoint and pay for the team of tax professionals to deal with this matter to ensure a fair outcome against the South African Revenue Service. So it's an insurance product in its typical sense, similar to if you own a motor vehicle. You know that there's a risk that you'll be involved in an accident. You hope it never happens. The insurance company hope it never happens, but you know there's a risk. And there's one or two ways you can deal with this risk is either insure it yourself. In other words, if the unfortunate does happen to you, that you are responsible for those damages, it comes out of your own back pocket, or you can elect to buy insurance and ask the insurance company to carry that risk. And tax risk insurance does exactly that same thing. So you are at risk of a SARS dispute, even if you've done nothing wrong, and you can either carry that yourself, comes out of your own back pocket, or you can ask us to carry that risk for you. So this is the type of taxes that we cover. We cover almost all local taxes. So we cater specifically for the small to medium-sized enterprises. And then the shareholders and directors and high net worth individuals that sit around their businesses. So more your complex tax categories in income tax, VAT, pay-as-you-earn, capital gains tax. It includes representation into the tax board and tax court. So this is what this graph shows you what the compliance revenue is that SARS managed to collect during the last tax year. And it's a significant amount, and it grows every year. So in the previous year, SARS collected just over 260 billion rand in compliance revenue. Compliance revenue, of course, is when SARS audits taxpayers, and as a result of those audits, they are able to collect additional taxes. And the last tax year, SARS was able to collect 604 billion rand in compliance revenue. So that's a massive amount. And it doesn't only come out of the pocket of the criminals, right? Those people that you read in the newspaper. So this that encircled segment at the bottom of your graph shows the amount of tax that SARS collected from criminal and illicit activities, and that's only 30 billion rand. Although it's up significantly from the previous year of 20 billion rand, which is good to see that SARS does go after the criminals, it makes up less than 10% of the overall compliance revenue. The rest of compliance revenue comes out of the normal taxpayers like you and me and your clients. So the overwhelming majority of compliance revenue comes from normal taxpayers, not your criminal and illicit economic activities people. So, and also the situation is not looking to improve. We know, and you as the tax practitioner will also know, that the pressure in your office is increasing significantly. And that's because SARS has just appointed more resources. In not this budget announcement, in the last year's budget announcement, the year before this, SARS, the government committed 7.5 billion rand additional expenditure to SARS to increase their capacity. In that time, in the last year, SARS has employed 1,500 new tax auditors. It's a massive amount of people. And not only that, SARS is heavily investing in technology like artificial intelligence. So not only do they have more people, but those more people are able to get through the work more quicker. So that puts a huge amount of pressure on you as the tax practitioner, as the tax advisor, and your client as the taxpayer, because tax audits or tax verifications, which leads to audits, which may lead to disputes, are increasingly significantly, and I'm sure you will feel it in your practice. So tax risk insurance will alleviate some of those pressures by dealing with those audits and dispute as they come. So here's a list of the benefits. It removes that uncertainty. We've already spoken about that. The premiums are really affordable. We'll have a look at that shortly. Cover is retrospective, and there are no waiting periods. So if you buy your client buys his cover today, and SARS writes him a letter and informs him about an audit from 5 years ago, then he is on cover. So cover is retrospective, and there are no waiting periods. We appoint some of the best tax specialists in South Africa to represent your client. It's important because the policy brings proper skills to your client. These aren't people that work for us. These are people in private practice, like Dr. Erasmus and his team. So your clients will be properly represented during these things. Most importantly, your own fees are covered for the duration of this claim. So we know in many of these problems, because you represent your client, you're acutely aware of your client's financial predicament, you can't charge your full fee, or you can't charge your fee at all. So you are forced to write off a portion or all of your fees in the best interest of your client, which is understandable, right? But it's not fair. Your time is your money. And with this product, you can also, your own fees will be part of that claim for the duration of the claim. And importantly, you are the central part, right? So we see you as the tax practitioner as the most important part of this team, because you have the relationship with your client. You've already done his taxes, you understand the background. So we have an incentive to make sure that you are a central part of this team and that your fees are paid for services rendered. So here's a short table of what the premium is typically like for companies. We look at companies' annual turnover. So for small companies, it starts at 265 Rand a month. And if you're a large company, you have 100 million Rand turnover a year, your premium is 1,540. It's really a negligible amount of premium that your clients pay, considering the nature of the risk and the complexities involved in dealing with those risks. There's really no reason why any taxpayer should not take this cover. And we ask that you introduce your clients to this. For individuals, especially for the high net worth individuals, because the risks are higher. You can see there's the premium structures for your high net worth individuals, like the shareholders and directors of these companies. And so this is what an application form looks like. It's not a long, complicated application process. It's really a one-pager. Top part, we ask who your client is, so it has these details. The middle part there, you'll see it's a debit order facilities, so we can collect some premium. And the bottom part is some underwriting questions. There's 7 of them, yes and no type answers, where we try to establish the nature of your client's tax situation at the moment. It's an insurance product, so we need to understand the nature of this risk so that we can underwrite it properly, right? That's the nature of insurance. But it's not a long, complex application process where we ask too much detail of your client. It's really one pager. It can't be any simpler. Part of the application process is the rates. We've just had a look at it. So your client will immediately know what is covered for, what his premium is, and what the limits of his indemnities are. And there is the front page is a summary of the cover. So to make it easier for your client and for yourself to understand what's covered and what's not covered, we've put a summary of the cover in one page. It's, of course, subject to the full policy terms and conditions, but terms and conditions are often very difficult to work through. So this summary then gives you a very nice holistic view of what's covered, how does it work, what your excesses are, and almost most importantly, what's not covered. So that's all included in the summary of cover. So it's really quite a nice one-pager or 3 pages as the case might be. It can't be easier for your client to get proper protection against tax audits and disputes. If you need more information, you can go to our website. There's some case studies in there. You can download application forms, etc., etc. at www.taxrisk.co.za. There's my contact details. By all means, take it down and give me a shout. I'm more than happy to help you with that, especially how do we introduce your clients to the product within the confines of insurance laws. Of course, you need to be an authorized financial services provider to sell insurance. So we'll talk you through it. You as the tax practitioner are not necessarily an authorized FSP, and we will then introduce a broker to help you with those regulatory compliance stuff. So we can talk about that. So by all means, give me a shout about it. Dr. Rasmus, I think that's all from me from a product point of view.
Thank you. Thanks, Willem. Okay, so do we have any questions? Happy to answer them.
There's no questions in the chat box at the moment, Daniel. I think the presentation was comprehensive, so I think we're fine.
Okay, thanks very much, everybody, for attending. Please take a look at the courses from Gil. They will really help you tremendously. And if you have any interesting issues that arise, something that you think about after ending your participation in this webinar, please shoot me an email. I'll be more than happy to answer it. Other than that, once again, thank you to GreatSoft for the opportunity and to all of you for attending. Willem and Gil, thank you for assisting in the presentation.
Thank you very much. Bye-bye.
Cheers.